Welcome to the show. Against my better judgment, hit the like, smash subscribe. Let's go. Let's go. Welcome to the show. Let's go, let's go, let's go. Welcome to the show. Against my better judgment, hit the like, smash subscribe. Let's go, let's go. Welcome to the show. Let's go, let's go, let's go. Welcome to the show.
Hello, all of you beautiful, wonderful people out there. Let me get to the comment section. I'm running late as usual. My apologies. But hello, everybody in chat. It looks like Bright Red Dot was here first. Left, my job is done here. Left a like, my job is done here. I appreciate that. Jeannie is here. All right. Yes, we're on our way to 6K followers. Let's try to hit that 6K today. I think it's possible. I think it's doable. Okay. I was working on a video that I made for you guys this morning. It's like this close to being done, this close. I just have to finish like a couple of final touches, and I was trying to rush to get it done. So hopefully while we're watching the trial, I can upload it and you guys can watch it later. But I still have to add a few things, and I'm kind of like losing my mind here. Let's see who's all in chat. Real Aspen Donors here. Hello. Missed the morning. Glad I'm here now. That's okay. It didn't start until now. It's not starting until like 10 minutes, 13 minutes from now. It's supposed to start. They were starting late today, so we had a late start for the day. Let me just pull it up. Yeah, they are live. They haven't started anything yet. We're still awaiting. So we made it just in time. What's up? Jostle's here. I think I'm saying that right. Snoops is here. Why did Erika wear an aggravated court? Because she wanted everyone to know she wasn't hiding assets. On fire early, Jostle says. Cindy's here. What's up, Cindy? Yeah, define evidence. I love that one. Honey is here. Hello. Up my blue page. All right. Robin is here. Hello. Who else is here today? So far, I think I saw. Oh, Ra is here. What's up, Ra? All right. Girlie's here. Hi, Girlie. Derek's here. Hi. The Smutty Truth is here. I love that name. Fiona is here. Hi, Fiona. All right, guys, welcome in. Chuck Soup, Conky is here. Welcome. Jen is here. Welcome in, Jen. Louisa Miller. All right, Louisa, welcome in. Just want to make sure I'm saying everybody's names all right. A lady is here. All right, I think that's everybody in chat so far. Do we want the chat up on the screen for today's thing? Do you guys want that up? It is a little bit helpful to see since we have two streams going. Let me make it big. Boom. That's nice to see, right? We can see that. Sasquatch is here. Hi, Sasquatch. Honeybee says, hello, everyone. Hello, hello, hello. Hello, hello, hello. Yeah, sorry. I was a few minutes late. I'm fashionably late, okay? I'm a lady. I'm fashionably late. Ladies are allowed to be fashionably late sometimes. Okay? Okay. 20's here. What's up, 20? Okay, let's see where we're at. Let's present this court hearing. Let's see what we're looking at here. Let's check it out. We'll get rid of their chat. We don't care what their chat says. Our chat's better. Our chat's better. Okay. And we're just looking at the building so far. Stay Ready is here. Art on lunch. Okay, I'm glad you popped in for your lunch break. That's amazing. Please don't forget to hit that thumbs up. All right, on your way in. This is day 3 of the Charlie Kirk case preliminary hearing, the state of Utah versus Tyler Robinsin. We are here to take a look at the evidence and see if there can even be a court case. We're here to just see if they can even, there's enough evidence to prosecute this guy, right? To even attempt to prosecute this guy. Now, so far what we have seen has been a joke. We've seen nothing. We had some huge surprises, right? We had a holster that they just left laying there. There was another pew pew on the scene in somebody's backpack. We had a bullet up on the roof of another building. We have all these things. We got Lance Twiggs DNA on all the evidence. I mean, hello. Just that alone creates all those things in their own right, create a huge amount of reasonable doubt. So if they're going to use these pieces of evidence to try to actually move forward with a trial and try to prosecute Tyler Robinsin, any one of those items creates enough reasonable doubt that if I was a juror, I would not give anybody the death penalty, let alone, convict them for life for unaliving someone. That's insane. You either have an airtight case against a person because they are 100% guilty, or you do not. And from what I see, there's really nothing there. Really ridiculous. So far, it's like we're on day 3 here, and today's a half day, so we're not going to be too exhausted when it's over, right? We're still going to have a little bit of energy and joy in our lives. They literally suck they just suck your spirit right out of you when they're on here. It's crazy. Cheesy Brats is here. All right, got 15 minutes, then back later. Okay. Yep. Let's see. Yeah, so far they have not eliminated mythical creatures as a viable suspect. That's true. Yeah, it's a bit of a whirlwind. Salty Boo Boo is here. What's up, Salty Boo Boo? How are you? I hope everyone's having a great day. We're going to have a blast today. This is so much fun, right? We had an amazing time yesterday. No, I'm just kidding. It's a long day. It's a long, hard thing to watch. It really is. But I feel like, we've been following this case the entire time. I feel like it's, our duty to witness this and watch, see what the hell's going on. Try to bear witness to this nonsense. I think people need to see this and realize what's really going on here. Derek is here. Welcome in, Derek. Yeah, the fact they just rolled past Tyler, met with TPUSA employees is wild. Yeah, that was kind of strange, right? That was kind of strange. Yeah, we're here to listen to more bullshit. We're going to bear witness to all this BS. Yes, please don't forget to hit the like, share, and if you're new to the channel, please subscribe. We're going to hit that 6K today. I know we are. I absolutely have faith in us. I think we're going to do it. The more you guys like and the more you guys talk in the chat, the more YouTube will share the live out, and hopefully the more people see it. We need a lot of people to see what the hell's going on here. It's boring and stuff like that, but I feel like it's necessary that we watch it. I feel like it's necessary for Tyler's sake, for the sake of the American judicial system, that they realize that they got thousands of eyes on them at all times. We can't let off these people. Oh my gosh, and over on X, so much stuff is going on over there. I have a whole video for you guys with a couple of absolutely insane things that have been um, going on over there. Some things that people have said, posts that were made. I mean, just crazy, crazy. I'm going to get that published and get that up for you guys, hopefully, hopefully today at some point. Maybe I'll be able to do it while the trial's going. I can listen and we can just because it's so important, we're gonna listen to everything they say. But I can listen in and finish that up and then upload it, and it'll be there for you guys. Hopefully, fingers crossed. This dude will be convicted and given the death penalty. No evidence, and the clients walk free with all the evidence. Such a messed up world. You know what? That is such a good point, Derek. That is such a good point. If this happens, this is gonna be such. I mean, we've already witnessed the people in the e-files they're just chilling, walking around, right? Walking free with all that evidence that's on them, just, and this will make it even worse if this happens. You're right. And I didn't even really think of it comparatively like that, but you're 100% right, Derek. That's crazy. This crazy world we live in. Yeah, I don't think he did it alone. I mean, I think he had something to do with things, right? He was cool with doing whatever they wanted him to and placing things here and walking around here and being in this place at this time and things like that. I think he was involved in some way with what went down that day. I do not think he was good enough to take that, from across the roof. Roll down 30 seconds, do it, hit the mark, get up and exit stage left. No way. Miramar Marie is here. Good morning. This is the only way I can make it through this dry court proceedings. Thank God, decided not to be a lawyer. I know. I thought I wanted to when I was younger. My cousin actually went to law school and she's been studying for the bar exam. She's having a heck of a time. But it's like, I honestly, sitting through things like this, watching this stuff unfold, it's like, I don't know how these guys do it. I really don't. They've got to be. Oh, could you imagine this every day, knowing this is what's coming every day for you? You have to go to this court hearing and, oh my gosh. And the way they have to get people to say things in such an offhanded, sideways manner, like that whole DNA thing we watched yesterday, that was hours of him just asking all these strange questions to try to get her to say a specific thing. It's just so much. It's just, they're already working on a clone for Tyler, and the real him will be taken out soon. I believe that. Oh yeah, that's my video. Stay ready. I made a whole video about that. I'm in shock with that news. I don't want to spill the tea here because I want y'all to watch my video. But yeah, I'm like in complete shock about that myself. I couldn't believe Ben said that. I can't believe that's actually what happened. And you guys are going to just be in shock about it as well, I think. I'm going to make sure. I think I did download this already. Yeah, I did. Yeah, I just want to make sure I get this done for y'all. Let's see. Yeah, this is a pretty wild things going on. And also the whole thing with Frank Turk over there too. Frank came out again and he's like, oh, I'm going to clear some things up. And basically he wanted to clear up the fact that he said at one point in time, I guess Frank Turk claimed, excuse me. At one point in time, Frank Turk claimed that there were drones flying over UVU that day because he saw it from a video Charlie was sent to Charlie's cell phone. It was a video of above the crowd. And he said he saw that video and he assumed it was a drone, but he wants to clear it up. He said, I want to clear this up. He said, I think what it was somebody standing in that tunnel behind where Charlie was sitting and they were taking a video from up there. He thinks that's what it was instead. He's like, I just want to clear that up. And it's like, you really didn't clear anything up because you guessed. First of all, you guessed it was a drone, and now you're guessing that instead it was just somebody standing there with their iPhone taking a video. It was the dumbest thing. I just don't know why these people come out here and try all this nonsense on us like we are 2 years old and gonna just believe anything that comes out of their dumbass mouths. It's crazy. It's crazy. It's just so retarded. And then, oh my gosh, and then guys, Blake, my favorite bald-headed bastard. I didn't even get to this in my video. Blake Neff was on a Spaces with Diligent Denizen and a few other people, and they were trying to ask him to ask Terrell Farnsworth about that video. And was it altered when he sent it to the feds? And Blake's like, I'm not going to be asking him anything. I think he's been through enough. It's been enough. It's like, really? Well, you decided to involve yourself in an active crime scene, and you decided to snag up some evidence from a federal crime scene. And, well, now it's just a state crime scene, but it was like at the time the feds were there and all that. You decided to insert yourself in that, jump up on a chair, screw up the whole crime scene there, get your, do all this stuff. Like, that is such a big, huge deal. Jump up and grab footage out of a camera. And now you don't want to, he's like, I don't want to bother him. He's been through enough. Like, bitch, no, you haven't been through enough, because your friend got, whatted down, and you decided to insert yourself in that crime scene, mess it up, and then run around the building and go, he's dead, Charlie's dead, before you even knew what happened to him. That's what was very suspicious to me, that Terrell Farnsworth even made that video, because he ran around the building, he stopped, wasn't even that far away. Everybody else is freaking out. They're loading Charlie into a vehicle. He didn't even, see like up close what happened to him. And he's already saying he was deceased. And it's like, bitch, how do you know? Then why are they rushing to load him in a vehicle if he's already gone? So why did he say that and assume that Charlie was deceased when he turns his camera and you could see footage of them loading Charlie into the vehicle? So what the hell? It's like that you do all of that, and now you're gonna sit there and say, like, you don't like. Then we got, what's his name, saying, like, I don't want to disturb him. He's been through enough. He's been through enough, guys. Terrell's been through enough. And doesn't he have a Farnsworth as one of these lawyers up here anyways? Like, there's Farnsworth in the case, and oh my God, it's just insane. Mm-hmm. Yeah, that stuff with George Zinn. Yeah, don't say the P word in chat. Say something like corn or something. We don't want to get any flags for that. But yeah, they did. They busted him with something, and somebody made him say stand up and scream or something like that. Stand up and scream. He did it to distract people. And nobody's like, that's not even been talked about. But I mean, I don't know. I think the defense might have that in their list of things maybe that they want to talk about. So far, we've only been looking at the prosecution's evidence. We probably won't even see anything from the defense, right? Why would we see that here, right? This is just for the prosecution to show their evidence, isn't it? Or will we see stuff from the defense in this case right now? Not real sure. I'm not real sure, but I would imagine they would bring that up. Like, why then suddenly did this guy jump up and say this, in the middle of this active scene here? Why is he jumping up and saying this? Because they would want to know about that. That's some important information, because he did say something like he was, he was told to jump up and say stuff. I thought that was super weird. Like, why in the world would he be jumping up to say it? Yeah, distraction. Like, why is he jumping up to be this big distraction? I don't know. I hang up on FaceTime carrying my purse and Starbucks and keys, right? Frank was on FaceTime for hours. Yeah, he was on FaceTime for like 10 hours. He was on FaceTime for like 10 hours. Wait. I can't find it again, babe. Hold on. Wait a second. Yeah, I'm going to delete that comment about that just to, just be careful what you say in the comments, because we don't want to get flagged. We don't want to get in trouble. Yeah, on my last video, I had a couple people comment because I said Philadelphia. Like, I think by now we all know what Philadelphia means, but people were like, saying like, oh, you don't want to say it and stuff, but it's like, we don't have free speech here on YouTube. They say we do, but we really don't. We have to watch what you say. you know, because they still flag you. They will demonetize you. They'll take your video down. You'll get bots in your chat because of stuff that you say. Like it's like a very precarious thing unless you're Candace Owens, who has 6 million subscribers, and YouTube's not going to do shit to you because you're bringing all kind of money and attention to YouTube. Well, when you've got 5,000, yeah, they're gonna come after you for saying stuff. And I can't. I told one of them, told a couple of them off because they were saying ignorant stuff about it. So I told them off in the comment section. You know me, I couldn't help myself. But yeah, just because we called it Philadelphia, goth. I'll call it whatever the hell I want. How about this? I don't work for you, and I'll call it whatever I want. I'll do whatever I want here on my channel. They're so annoying. And yet the thing about YouTube, guys, is it's voluntary. You can switch. If you don't like it here, you can go where there's a whole bunch of other people out there doing stuff. You can go see somebody. You don't have to be here. So it's why are you commenting if you hate it here? Obviously you love it, or you wouldn't be here commenting. I hate people like that. Right? The one guy, I told somebody to fuck off, like I did the Frank at the end of my video about Frank Turek. The other day I said, fuck off, Frank Turek. Well, then somebody had a rude comment in the comment section, and I was like, you can fuck off just like Frank Turek. I told someone in the comments that. I was so mean to them. I don't think they came back after that. But yeah, F you, F off, F you. Exactly. That's what I told them. It was annoying. They were questioning something or being rude about something, and they were rude to somebody else in the comments too, and I don't go for that either. I don't go for that. You can be rude to me because I'm rude, and I fully expect people to tell me off and be just as rude back to me. But when they start going after other people in the comments, I don't like that, because the comment section isn't the people who are saying this rude stuff. I am, so when people in the comment section say something and then other people attack them, I get kind of mad. It's like my little babies. I get mad like a mama bear. Yes, that's so true, Derek. Exactly. You can tell who runs the world by who you get banned for making fun of. They love it when you make fun of Christianity, but don't you dare talk about the other little hats. Exactly. Exactly. You're not allowed to sit you'll literally get bot attacks all in your comment section. And then when you get bot attacks, YouTube has an AI that goes over everything we say, every one of your comments, every word that comes out of my mouth, everything I put up on the screen. There is AI going through all of it. And if you suddenly get attacked by a bunch of bots, guess what? They suddenly start thinking your channel is a bot channel, and they'll literally suspend your channel. They'll take it down. I don't want none of that. Guess what? If you can't figure out that I'm saying Philadelphia and I mean something else, you shouldn't be here because you're too stupid. You're way too dumb for my channel. You need to just go anyways. We don't need you here. And I don't like that, if you're going to get butt hurt over stuff, again, you don't belong here. We're not like that here. We don't do that here. We have differing opinions. We can sit here and argue respectfully. Everybody can weigh in with their opinions. We all have different opinions. That's expected, but don't sit here and get butt hurt over stuff and cry about stuff, because we're not going to listen to it. We don't care. We don't care if you're butt hurt. Move along. There's other channels you can watch where they can, they'll put some Vaseline on your butt for you. It ain't going to happen here. Oh, thank you. The smutty truth. That's because it's off-planet entities that own us. Yeah. You know what? I do not discount that theory. I don't discount anything anymore. It's too crazy out here. There's too much crap going on, and I don't discount any of that. So thank you so much for the super chat. Thank you so very much. Hold on. I do have a little thank you for you. Hold on. Boom. Thank you. Thank you. Thank you. Thank you. Very sweet of you. Much appreciated. That helps out so very much. So I thank you for that. Yes, for the full screen version, if you are on the vertical, see, the thing is, the vertical, you can type easier. The vertical, you can chat better in the chat section, but the full screen, you can see everything better. And then when you want to type a comment, you have to turn it vertical anyways to get access to comment section. So it's just whichever one you prefer. But there is a link to the full screen version of this video right in the very top of the description there on the vertical version of this live stream. You can click that and come over to the other section. Otherwise, you can take, if you want to see who's commenting what, pay attention to the comments that are down in that corner over here, and you'll be able to see both chats on both of the live streams, and you'll be able to kind of interact that way. Let's see. George pled guilty to obstruction and something else back in January, and he is in jail now. Okay. Yeah, you know, that's another thing. Once, like we were saying yesterday, like once this whole thing is all over with, if Tyler's locked up, he's gonna start talking, you know. Welcome in, Beaner Cheek. Yeah, everyone should check out Rich Tidwell's Synagogue of Satan. Yeah, okay. All right. Off Planet, welcome in. I think I said hi to Sasquatch, Robin, Golden Cat, undue listener, Saron, thanks. Oh, thank you for coming over. I appreciate that. No, I don't know that I've paid attention to that one. Is that the one Candace has on her show? Because I know she plays a Kanye song for her intro. Oh, it was Charlie's favorite song. Okay. Yeah, GQ Man posted the link for the full screen in the comment section if you prefer that. Yeah, if you're on your computer, the full screen's nicer, and vertical sucks on the computer. If you're on your phone, it's like a little bit smaller, but as long as you can hear it, you know, that's the main point right now. Because honestly, looking at these people sitting up there in court's annoying anyways. Like, you can't really see much. They don't have really a good whatever. So it's like we're all just looking at the same one person far away anyways. Even when you have it full screen, you really can't see much. So it's not like we, you know, are looking at things, but we're waiting for this to start. Let me see if I got behind it all. No, it's still waiting. Let's see. Still waiting. Tyler showed up at UV with a burgundy shirt on. Oh, really? It's totally Charlie. I'll have to really pay attention because I'm sure I heard that. Snoops, I don't hear the judge. I'm on court TV and I don't hear the judge speaking. We have it turned up. Let me see if I can go to the Utah version. Utah has a version too on their news channel. What one was it? What channel was that again? The Utah. Yeah, Real American's Voice has it.
Leading the jury undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the two videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor.
We're going to watch this one. This one ain't loud enough. Never mind. We'll watch this one.
You really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates playing it in the courtroom or on television, well, for the media, I find that it is. Well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom?
Yes.
Can I make one suggestion, Judge, or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that.
Isn't this from the other day? Is this today? Because this sounds like this is the same thing from the other day.
Any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right. Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or
I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury.
Here's the one for today, but it's low. I'm going to try to find a louder one.
There's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move. That conforms with 104B.
This is a little
That's our
louder.
intention, unless the court or counsel moves to close. Unless the court or
There we
counsel moves
go.
to close the hearing. So, in summary, the court could,
There we go.
the court can, and often should consider evidence and
Goodness
review the exhibits
gracious.
before admission. 2, the court is not tainted by doing so, and
Okay.
can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have two microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thoughts, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
They're gonna, I just need some other tables besides 3, so we can try.
All right, if you, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, and if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up, because that could cause a delay. I just want to knock this out first. Yes.
If you would prefer, I mean, we could promote TV or by media, so they can see it, or there's more of them, however it works.
Where would that TV go?
The lower, kind of along that back wall, if you wanted, we've done that in trials before.
If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
I need them to actually plug in their HDMI. so
I
we
see.
can test.
Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here. I appreciate the parties' patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up.
It's looking.
All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go?
15 if you want, or if you want to just use this, that's fine.
Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right. Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
A total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, officer-involved critical incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I've worked anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. Faro certified. It's a 3D Faro scan of crime scenes.
What's a Faro scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've. So, as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City Airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the 2 pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinsin.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinsin detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, following, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinsin at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version.
Thank you.
That may happen a couple more times as we go through exhibits
I
because of agreements and disagreements that we have.
All right. Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinsin, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinsin at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinsin was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct. Yeah.
So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that's probably right. The difference.
It has no audio, so we would like to admit and publish it at this time.
All right. State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with a, that's like a, I believe it's like a, maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at, it was the St. George, well, it was the St. George court office, courthouse there. They met and discussed briefly, just kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt? The same
You may.
purpose.
All right.
And how do you know that?
I've reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
What in the world are they back there doing? Talking all kind of smack, having a whisper party? I cannot. I love how they
I apologize, Your Honor. I misspoke. It's not
Driving me crazy.
14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record, defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you. All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented, not been fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. Are you've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinsin.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution, from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second, or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not, I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one,
I don't like this
2014 UT App 165.
She needs to shut the hell up.
And State v. Rosecrans 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And in regards to this exhibit, is in the, as State's Exhibit 16, is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, so turning to the defense, Mr. Novak.
Thank you. Thank you, Ms. Hunt. So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit which may not be admissible under the rules of evidence at a preliminary hearing be played in open court and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102 those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today, we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it would probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it until we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinsin's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't until 20 minutes ago even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now, but I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to what this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
No,
I just want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
sure,
because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Okay. Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits there are no disputes, these exhibits there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing. And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closer analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview, that it's at issue here, is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
Then we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit, of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
thank you. All right, right now what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
and
fair enough.
maximizing the time, because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief recess.
All rise.
Oh my goodness, these guys are something else. Holy cow. This is like, I am getting brain fried. And this lady, dude, I can't listen to her. She is just ruining my day. My God. Angela, I found you on Discord. I DM'd you. I don't know why I couldn't find you before. But I didn't see anything on Discord from you, so I just DM'd you, and then I tagged you in the server to try to get you to see if it would show you where we're at. Jeannie's just said she just got home. She got storms and stuff, so she'll be probably heading over to the live stream, so that's good. But anyways, yeah, what is like, oh my gosh, these people this morning are driving me insane. Let's see what all these other people got going on here. Let's see, any of these other streams any good? Is there still, oh yeah, they still got a sausage fest going on for their stream. The guys do. Wow. Valhalla got 10,000 people on his stream.
We just eject the rounds and pick them up later, not out of AR-15 style platforms. They do not do that. If this was some bolt action sniper rifle, maybe still they probably wouldn't do this. Maybe the police officer does that.
What type of bullet it was, yes.
But now keep in mind, he wasn't in the grass. He wasn't somewhere where that round could have fallen. He ejected it on the top of a white roof. And
And
they
it's an unspent round, right?
Yeah, and somebody in our chat said a police officer for 25 years, and there's no way that a police officer would leave a spent a round sitting on the rooftop. There's no way. And also somebody brought to our attention yesterday, why would they try to yes. Yeah, another sausage. Why would they try to take it out and do all that on the roof? They would be back at their car trying to make sure there was no bullet in the chamber of their weapon when they got to their car. They wouldn't be doing that just randomly on the roof that day. That just wouldn't be the case. And so they're just trying to dismiss that as like whatever. And I'm sure they're going to find somebody to lie about that round. I'm sure of it. I have no doubt in my mind they're going to have somebody that goes, oh yeah, that was, such and such. And I don't know if I would believe it. I really don't know that I believe that they know where that round came from at all. I don't believe it.
Oh, and they were talking? Dude, I was up at one too.
Yeah, Jesse, that would have been perfect for you.
Oh my gosh. That would have been so fun. Like, Blake, hey, everybody Charlie on here and let's really hash this out.
I don't know what they got going on over here. Let's see who else is. Let's see who else is on here streaming. I'm not really into the sausage fest. I'm sorry, guys. I'm sorry. I wasn't invited to the sausage fest, so we're going to look at somebody else. Diligent Denizen is doing something. What's he over here doing? He's live too.
Is that Tyler Robinson turned himself in at 9 p.m. accompanied by, the sheriff brought him in, the retired sheriff detective brought him in, and that he did so accompanied with Tyler Robinson's parents at 9 p.m. Now, why is this important? It's important because the text messages to Lance Twiggs and the Discord group chat are around 7 p.m., right? Or around there, right? Different times. We don't know exactly when the Discord text messages were sent, right? So we don't know exact timestamps, but we know that they're before 9 p.m. Well, why is that significant? Because if Tyler Robinson, according to his, the family that I've spoken to, turned himself in the afternoon of the 11th.
Yep.
If he turned himself in the afternoon of the 11th, he can't have sent those text messages because they confiscated his phone as soon as he got there, right? So why is the timeline so important? That's why the timeline is so important. If those text messages were sent after Tyler Robinson was already in custody, Tyler didn't send them. And then the question becomes, who did send them, right? Who did send those text messages if the authorities had his phone? And then there's another thing, right, is that, I won't go there yet. My point is that, so we just caught this guy making a mistake in his testimony, and I'm going to play it for you now because it is very, very interesting. Very, very interesting. Okay. Here we go.
To the Washington County Sheriff's Office.
Yes.
There's no
What
volume,
time
is
did
there?
you arrive there?
I'm not hearing
Somewhere
anything, no.
Close to midnight, maybe just a little bit before midnight of the 11th.
Stupid.
What happened next?
So I met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how
That's
to
weird. It's
handle
not even showing the tab.
the situation there.
Did you mentioned.
Oh, you
the
have
reason
to
were
have
down
another
there was
tab.
you
My bad.
Had been told
It's
that
okay.
an individual wanted to turn
I
themselves
mean,
in.
That's correct.
it's definitely
You
interesting
observed
to
that
see how much they
individual.
don't want the press to
And
also
where
be
was
involved
that
or like
person at
us
the
to
time?
see what's
So
going
when we
on.
arrived,
Who is talking in this? I hear a lady, but I don't see a lady. He's showing his whole screen.
Ridiculous shit to,
an individual on that screen that was sitting in
out
one of
certain
the soft units.
Yeah, he's got too many confusing things going on over there. That's like way in my face confusing. Let's see what Kelly and these guys are up
Charlie
to.
Kirk, right?
I thought Kelly was going to the courtroom. she was in Utah. Remember, she was there the day one, and she got some footage outside, and then she was going to be in court the next day, but she's now sitting here chit chatting. So I wonder if she left the courtroom or if she didn't go today.
Interested in the Charlie is Alive track, so we'll try to do that. Yeah, that like leading the witness, you know, technically, I guess, is allowed in the police, in the law enforcement world during that questioning sort of initial stage, but it's not a good look. It's not a good look.
Definitely not a good look.
Yeah, and it doesn't,
Look, it's not a good look for us, like watching from home, but this judge, he's all about this. He is all about just hearing every little, like, he wants the tea. This is a trial for the tea. This is all this is, because hearsay's allowed. This is just a tea trial, right? He wants every little bit of tea. He wants to hear what she said, he said, his brother said, his cousin. They're like, look, you know what? Some dude I met at the grocery store, his aunt's brother met a guy who happened to know Lance Twiggs's uncle, who said that Lance said that he saw this and that. And the judge is like, really? We're going to admit that into evidence. We're going to admit that. I got to consider that into this trial. I got to, you know, he's listening to every little thing. Like, it's crazy. And they're spending more time arguing over what evidence that we're allowed to see, the public is allowed to see during this trial, because they don't want to taint the jury pool, right? But everything they're doing already seems very tainted, in my opinion, right? In my opinion, allegedly. Allegedly. I'm going to start wearing this every time I'm on camera. In my opinion, allegedly. Everything they seem to do sounds just ridiculously. They don't want to show the public, but it's a public trial, right? It's very strange to me. I really have never paid attention to a trial like this. I've never watched a trial like this where, you know, they had all this stuff going on, you know, where it was like all this hearsay. I've never seen that. I've seen like legit trials, and I know that every little detail when they try to get them to answer takes a really long time, and they got to ask all 52 questions to get to one little point, and it does take a while. But this is like, it's wild to me. It's wild to me, the evidence that they found that we never knew they had, you know. I did I did mark off, somebody actually on X made a list. Hang on, what the hell is this asshole saying? Andrew Kovac, timeline note, Utah SBI agent Brian Davis just testified that Tyler turned himself in at 9 p.m., not MDT on September 11th at approximately 9 p.m. MDT on September 11th. A whistleblower who described himself as a friend of both Robinsin and Twiggs provided a screen grab of Robinsin's Discord confession to YouTuber Turkey Tom. The screen grab shows the confession was sent at 9:57 p.m. on September 11th. Or 7:57 Utah time, approximately 1 full hour before he turned himself in. I consider the Turkey Tom video a must-watch for anyone following this case. And I guess that's this. I don't know what the point is here. I have bad news for you all. It was me at
confession message to their old friend group server. It's interesting to me that he sent it in this server and not to Lance's new server, because I'm not sure why that is. It could just be that he was less familiar with the people there, but based on the kind of messages sent there, which we're going to go over later, it could be that he wanted to avoid having anyone say something that resembled support for his actions. In the original...
Really? So now I guess they're saying that, you know, if we believe this guy here that looks like a, you know, if we believe this guy who looks like a chode, I don't know. Baron covered the Turkey Tom thing, yeah. Yeah, Chuck Soup, this isn't really a real trial. This is like just for the judge. This whole thing's a show for the judge so that the judge can decide should this actually be a real trial. And so we're just looking at a bunch of like, you know, nonsense until then. Somebody says strange how these fade away quickly with those who knew beforehand that Charlie Kirk would be unalived and that one of Lance Twiggs' TikTok follower on the same day saying we effing did it, like these transy zealots knew and planned it, although I don't know. Wow. Watching the live feed in the courtroom, I think the judge is losing his patience. They're talking in circles. Yeah. Yeah, I would say that's probably true. What are these guys saying? I want to find that list for you guys. Hang on.
I don't think so. He was asked to go to Washington because someone had, because there was a suspect in Washington.
Mm-hmm.
So.
Oh, this is funny, guys. Check this out. This is Andrew Colvett posting again, and he said that Donald Trump Jr. literally comes on this newscast and says this. It's hilarious.
For obvious reasons, when that fatal shot was fired. How's she doing? What does she want America to know?
Listen, she is doing as well as she can be under the circumstances. She was obviously very grateful that Bettina and I were there to just support her. You know, obviously I've been friends with her as long as she's known Charlie. And she's just a great person, a mother trying to get by, trying to, fulfill her husband's legacy.
Show of hands, who believes that? Anybody in chat believe this? Just trying to fulfill, she's a great mom, super mom, just trying to fulfill her husband's legacy.
There's obviously a lot of sadness in all of this. I think there's a lot of frustration, frankly, that this could have ever happened. I mean, one of the things I did hear that was sort of shocking was that there were only 6 officers on duty, on this campus event. No briefing beforehand, no real set game plan, and 6 officers for a Turning Point event. And anyone who's watched the news in the last, decade or so would realize there'd be thousands of people on this campus. So, I imagine there's some frustration with that, but I think she just wants justice. She's doing an incredible job just holding it together, given the circumstances and the, sheer brutality of how this all happened. And, frankly, some of the sheer noise that has come after her and attacked her and the organization and all of that, which is, again, I've stayed quiet. I've supported her. We've talked, regularly ever since. I haven't been that vocal because I haven't known what's real and what's not. But having literally been there in the room, seen the evidence with my own eyes, it's very clear to me that Tyler Robinsin will be found guilty.
So we've got another one, Donald Trump Jr. out here violating, I'm sure, I don't know if he'd be considered one that shouldn't, is under a gag order. I guess not, because he doesn't work for Turning Point USA, but it's just another person out here discrediting our entire, judicial system, just like, fuck it. All that evidence, guys, that we saw the first day, all that evidence that they showed us the first day. Oh, wait, they didn't show us a single piece of evidence the first day. So I don't know what the hell he's talking about. I really don't. I've got no clue what evidence he happened to see in the courtroom that day for the, couple hours he was there. All that evidence. Anybody know what he's referring to with the evidence? Yeah, there's no clear evidence. We saw nothing the first day. Absolutely nothing. And he's full of shit. Okay? Anybody who watched that first day, he's full of shit. And for him to sit there and say it's obvious he's going to be found guilty for what? What piece of evidence? None of these news either. This pisses me off that none of these newscasters ask any more questions. Oh, really? What evidence did they show you? What evidence did you see, Donnie? What specific evidence did you see that this is an open and shut case? I don't know. I mean, multiple DNA on every item that they collected, that's reasonable doubt. Seeing other weapons there that day, reasonable doubt. Them digging up an entire crime scene before testing a single thing, that's reasonable doubt. Like, come on, don't be a dumbass. He sounds stupid as hell. There was not one piece of evidence that he happened to see that day in court. He's full of shit. Completely full of shit, in my opinion, allegedly. Okay? He's allegedly full of shit. And Candace evidently posted, "This is our daily reminder that the federal government hates us and thinks we are retarded." Andrew crosses out this part so that the sentence says, "This is our daily reminder that we are retarded." Andrew says, "Fixed it for you, Candace." I mean, he's such a grown-up. He's so grown up. You know what I mean? That Andrew, he is like such an adult. Such a fucking adult, right? I just can't with him. Yes, here it is. Baron posted this. Baron gave us a rundown. Baron has given us a rundown here of what it is. He says, "Please let the Fed sloppers who have reported the following before the preliminary hearing started. Number one, 89 to 95% of the DNA on the screwdriver and towel came from Lance Twiggs. Number two, the woman who provided the ring footage of Tyler Robinson's car reported it was driven by a bald man with 3 passengers. Number three, the limping man switched the legs that limped and bent the limping leg with ease every so often. Number four, the man alleged to be Tyler Robinson arrived on campus at 8:30 a.m., walked to the quad, and met with representatives from Turning Point USA. Number five, the officer who responded to the Lucy Center had his body-worn camera stopped working conveniently when he arrived at the roof. Number six, the officer who responded to the Lucy Center roof was accompanied by an unidentified man with a pew-pew and a badge from an unidentified agency. Number seven, officers have no identifying information for the person on the Lucy Center roof, including an inability to identify his height, face, or clothing. Number eight, officers can only state the guy on the Lucy Center roof was carrying a long item and cannot state that it is a pew-pew. Anyone, perhaps more importantly, do any of the Fed sloppers see a problem with any of this? And that's a damn good question by Baron Coleman. Does anybody, like any of these Fed slopping assholes, you've got to be completely and absolutely just like retarded, perhaps bumped your head. Maybe you suddenly got abducted by aliens. They sucked out part of your brain and you came back to Earth really goddamn stupid. I really don't know. But if you believe, you know, like Donald Trump Jr. says, like all this evidence, clear evidence on the first day that he saw in the first couple hours where he was in court with, Erika Kirk there, guilty. Meanwhile, the first day there was not a single piece of evidence, literally not a single thing that pointed to Tyler Robinson. They didn't even talk about the DNA at that point in time. Day number one, where Donald Trump Jr. was at the hearing, they didn't even speak about those things. They saw nothing on day one. Absolutely nothing. Let's see what the idiots at the Daily Wire are doing today. They have an article every day talking about this hearing. Every single day they got to tell us something stupid. So let's see if they have anything dumb to say today. If I can get it to work. It really ain't getting it to work, guys. It's not working. Come on. Wow. Let me see. Maybe search in here. Nope. This is all old stuff. Where is their most recent articles? Yeah, I don't know. News. Oh my gosh, this is crazy too. Okay, hang on, guys. I'm gonna pull it up for you so you can see it. Harrowing footage. Harrowing footage that made the tearful Erika flee Charlie Kirk's unaliving trial as Dawn and Bettina offer support. It had all the elements. It had all the elements of a modern day tragedy. The grieving widow quietly dabbing away tears with a white tissue. The president's son making a surprise appearance with his glamorous new wife, and a diminutive accused unaliver at the center of it all. But the second day of the preliminary hearing over Kirk's 2025 unaliving also had elements of a farce. A farce, guys. An afternoon testimony so utterly boring, 4 women who had camped out overnight to get courtroom seats quietly slipped away after just an hour. The day had begun with a phalanx of cameras mobbed around the entrance waiting to capture the main players. Donald Trump Jr. with his recent bride Bettina Anderson, Kirk's widow Erika, and his devastated parents, as well as Robinsin's own mom and dad, who scurried into the Provo District Courthouse dodging the lenses as much as they could. Inside, security was heavy. The 4th floor had been turned into a fortress, with the floor-to-ceiling plate glass windows blacked out with fabric to prevent any clear shot at those entering the courtroom. Snipers were stationed on the roof, while squads of heavily armed cops had packed into the lobby and into the courtroom itself. I mean, geez, oh man, they've got more security here than they had at Charlie Kirk's thing, didn't they? What in the world? Erika herself was flanked by a posse of 3 cloned dudes looking small and fragile at their sides. Reporters covering the hearing were swept into the courtroom first, where from their perch in the jury box, they were positioned directly next to the defense team and the accused unaliver Tyler himself. Not that seating arrangements appeared to bother the 23-year-old, who maintained a mask of stony indifference throughout the day as he sat, hunched over the defense desk in a crumpled gray suit. I love how they literally said yesterday he was cracking up, right? Remember they said he busted out laughing during some certain things, which we never saw, right? But now they're saying he just sat there stony faced, and they're ripping on his suit. Well, you know, the guy doesn't really have access to dry cleaners and an iron to get his suit all fixed up for court. What the fuck do they expect? Oh my God. Or anything of Erika or anything. Here's Erika looking fugly. God, that woman makes me sick to my stomach. Just looking at her picture makes me sick. I just can't even stand it. Look at her ugly ass nails, them ugly ass rings. Ugh, gross. Yet there were odd signs of emotion rolling his pen through his fingers as a picture purporting to show him positioning himself. Oh, look. Positioning himself to strike, his left thumb tracing circles on his thigh as his transformer boyfriend or former lover's name got its first mention, and a quick scratch of his left eye. Really? Oh my gosh. As reporters filed out at the end of the day, he offered a brief smirk, the most visible and discernible facial expression he managed in 8 hours of testimony. Really? He offered a smirk? What? Bro, what? Okay, girl. Okay, girl. The real emotion was to be found further back, where Erika, dressed in a black satin blouse and matching wide leg pants, sat in the 3rd row next to Kirk's visibly distraught parents, occasionally dabbing her eyes as she watched frame by frame footage of Robinsin's movement on the day her husband died. It proved all too much at times, with both Erika and his parents fleeing the courtroom twice in the morning. Sitting just in front of them, a few seats away, were Robinsin's parents, Matthew and Amber, who, like their son, didn't give much away, stoically facing Judge Tony Graff while chewing gum throughout. Chewing gum? I don't think the judge would allow gum, would he? Behind them and to the right was Don Jr., solemnly in a navy suit, and his new wife, Bettina, who added a shot of glamour to proceedings. Are they for real right now? She added some glamour to those proceedings because she's a badass bitch, yo. She added the glamour, not Erika, but Tina did. She was looking so good in her cream pinstripe suit and black t-shirt. Okay. Although the newlyweds spent the whole day Monday in court, neither made it back after Tuesday's lunch break, for which both should breathe a sigh of relief. Although Robinson's sharp-tongued lead attorney, Kathy Nestor, last seen mounting an unsuccessful defense of grief Author Corey Richins took center stage at the afternoon saw the floor handed to Michael Burt. Blah, 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 blah. Here's Charlie's parents as they arrived for the second day. Still no Erika around them, although they just claim they're hanging out. Oh, that's Tyler's parents. There's Charlie's parents. There's Tyler's parents. My goodness. For more than 3 hours, 3 painstaking hours, Burt attempted to prove flaws in the DNA testing that identified Robinsin, subjecting FBI scientist Amanda Baker to a tedious barrage of questions and waiving best practices manuals written in 1996 at the witness box. Man, this is crazy. Nestor's a veteran trial attorney with a number of infamous defendants on her resume, including the former polygamous religious leader Lyle Jeffs, synagogue John Ernest and Michael Kirk Moore, who was accused of issuing false vaccine certificates and destroying $28,000 worth of COVID vaccines. The charges against Moore were eventually dropped. Okay. Yeah, this is all just little boring reruns here. Never before seen image allegedly showing Robinsin on the UVU campus beforehand in shorts and a maroon shirt with a hat. Now, I don't know about you guys, but I can't tell this is anybody. I couldn't tell you. That could be any of us. Any of us. Any man. Any white dude. Really, with a hat on. I can't see how there is any distinguishing features on this picture at all. Like, at all. All them pictures look more like twigs dressed like Tyler. Yeah, it's very suspicious to me that they're trying to say this is him. I don't think Charlie's parents like Erika even a little bit. I agree. You can't even see his face. You don't even know if that's him. You can't prove it by video footage. And why did they get to say that that is definitely Tyler? That's what I mean. I don't know. I don't know why they could get to say that's him. That doesn't look like anybody. That could literally be anybody. I mean, if you just gave this picture to a random person who didn't know who this, like what this was about, and you lined up 10 skinny white dudes up against a wall with dark hair, and you said, who's this guy? Out of all them, who is this guy? They could not tell you who that is. You couldn't tell who that is. I think it's disgusting they're actually using this and saying this is evidence. There was how many guys with maroon shirts and shorts on that day at this event with hats on? I mean, how many guys in maroon shirts did Candace point out? It's crazy. Yeah. I'm rich, I'm famous, the gallery at the trial, exactly. Yes. The sight of Erika enrages me at the same time making me ill. She's disgusting. Then she opens her mouth and it's on. I hear that. And yes, I wish the judge had a bit of a backbone. That judge has been bullied and bossed around most of this trial by all of these attorneys. There's even a 12-year-old attorney, it looks like. That guy who came up today, he's like, but Judge, I think I just left my mommy's basement and I really think I know all about Discord. I know all about it. Like, dude, I can't with these people. I cannot. Okay, Robin says, I'm a widow and nothing Erika has done seems natural. Thank you. I love when we have actual widows that can weigh in because, yeah, nothing. I mean, not being a widow, I think of if I was in that position, what I would be like, and none of us can really put ourselves in that position. But even my thoughts, if I had to be in that position, make me sadder than her in that actual position, if that makes sense. Like me just going, what if? And if I was in her position, oh my God, I would be so devastated. That makes me more sad than what she's acting like now. Okay, so they're saying that he drove a gray Dodge Challenger for 4 hours to the campus And this is the vehicle stalking the area. Okay. Blurry ass picture of a vehicle. Could be anybody. The agent did not testify as to what Robinsin said to the TPUSA people. They also bought food from, Robinsin also bought food from a Chick-fil-A roughly 2 hours before. A police officer interacted with the suspect on campus the day after. Okay, that doesn't make sense. I guess they didn't realize who it was. They say Robinsin returned to the campus during the manhunt, but during his conversation with the police officer, he set off alarm bells. Okay, I missed that. I must not have heard that right. Hall said the officer had cop intuition about Robinsin, and he wrote down his license plate, which later helped investigators prove that the 23-year-old was on campus that day. That was they consider that bombshell testimony. And that came after prosecutors shared never before seen footage allegedly showing him prowling the UVU campus the day of. However, the prosecutors hit a hurdle on the first day, as Tony Graff rejected surveillance footage put forward by the state, as he was concerned it had been edited. It had been altered with circles around the items of interest, and zooms at key moments were there only to make it easier to view. Here's just people gathered outside. The day of one of the days there. Yeah. That's hilarious. This officer ran out of his body cam footage. He didn't have any for that day because it ran out of batteries. And I love how also he said he was with another officer, that he didn't know who it was. It just, he knew he had a you-know-what and a badge. And so he was like, let's go check all this stuff out. And so they were together. And then when he ends up on the roof, he says he's alone. So what happened there? Where did the guys split off from this? You know, where did they split off from each other? Why didn't this other guy accompany him to the roof? It's just weird. That's also hearsay. Where's the photos of the license plate? Yeah. That's a Challenger, not a Charger. Right. Yeah, why is it that we can get crystal clear images of celestial bodies hundreds of thousands of miles away, but cannot even get one clear picture of Tyler on the day? Yeah, there's not even one clear picture of him on that campus. Not one. Not one clear picture of him on that campus. And if you put them both side by side and ask people to identify, like if you put him and Lance side by side and ask them to identify which one of these guys is in the picture, you can't tell if that's Tyler or Lance. You really can't tell. Crazy. Yeah, exactly. That gets you every time. That's real grief. That's real grief and real pain. I found out Candace posted something over on X today. If you guys haven't seen it, I put it in a video, and I've released the video while this court was going on. I finished editing and released the video. You guys have to go over and check it out. I don't know if we have time. Well, you might. It's like 10 after. Did they start the hearing back up? Nothing yet. Oh, they might be starting the hearing back up here in a second. But yeah, I found out something pretty creepy about Ben Shapiro's security team. Yeah, it's pretty weird and strange, and he actually admitted something on camera that was very strange. And you guys, I put it in a video for you guys, so you have to go check it out when you get time, and let me know what you think about it. Leave a comment. You guys know I read every single comment. Even if I sometimes don't get alerted. Like if I say something back to you in the comment section and then you say something back to me, sometimes I don't know about it. It doesn't tell me that. It just tells me like fresh comments for some reason. And so I try to answer all of them, but sometimes I miss like if you comment back to my comment on your comment. If you feel what I'm saying. It's hard to explain. But I do read every comment, so go check it out and let me know what you think about it, because it's pretty strange. It's a pretty strange occurrence. I found it to be very disturbing. It has to do with Charlie on the way to the hospital. So you guys have to see what it is. And Candace flipped out. Candace flipped. For her being on vacation, dude, holy shit. She got a lot to say. She is on point. She's watching this trial. She's watching X. She's listening to everything everybody's out here saying. Like, she's on point. Like, she's on vacation, so she don't have to do no research. So she's like sitting on the internet waiting for somebody. She's like, say something, bitch. Say something. And she's on it. Plus, we got Frank Turek. I found a creepy couple videos of Frank that you guys are going to be like, what? What the hell? Weird ass bitch Frank Turek too. So there's that for you guys to check out. He just came out and he's like trying to say, because he got busted in those lies. People were calling him out for his lies, right? So people really went to town on him. So he came out and made an emergency live stream to handle all these rumors. I didn't go through the whole thing. I want to. Maybe we'll, I don't know. It's so hard to go live after this court hearing and talk about, like, I don't know. This takes up the whole day. Like, this takes up every ounce of energy to watch this. So it's hard to even show other stuff, because I would much rather show that live stream of Frank and rip on him so bad. You know, I want to snark on someone so bad. It's so hard being quiet through this court hearing. I just wish I knew what these idiots were out here doing, because he says a time and then nobody ever comes back at that time. It's 20 after. Let's see. Nobody's even doing anything. Yeah, Frank had to fix his lies with some more lies. Yeah, he was like, I don't think it was a drone flying over the campus anymore. I think it was someone recording from the route, from the that thing over top of Charlie, that walkway. He thinks someone was recording from that walkway instead. And I'm like, so you guessed it was a drone, and now you're just, instead of, because you don't want it to be a drone, you're just like, well, I guess it could have been a student recording from up there. And that's supposed to straighten things out. Like, get out here, goofball. Honey, girl, I feel you. I feel you. I do. And it was so hard to just play the clip of Ben so you guys could hear what was happening. I just put it right at the beginning, because I hate waiting for people to tell me the big news when something's happening. So I just stuck it right at the beginning. That's the video. So you guys didn't have to wait for a second to find out what I had to say. I put it right at the beginning of that thing. I was like, Ben Shapiro said what? And then I just stuck it right at the beginning, because I'm like, this dude, I can't take him. Him and his damn eyebrows. Oh, is he annoying? So annoying. Let me see something. Oh, wait. That's right on the bookmark. Let's see. Oh, yeah. Oh, yeah. Wait, guys. I'll show you this real quick. If they're not coming back to court, let me show you this. Shit. I'm gonna crack up at this. Okay, do you see it? No, you don't see it. Do you see it now? Yes, we see it now. Okay. This was
said,
Blake.
maybe, you know, like representing Erika Kirk in like a victim statement, not as like something that's factual, because this guy's never met Tyler.
No, Blake Neff was in here. Here we go. I want to see these speakers. Blake Neff ends up in this spaces. I don't know if we get, yeah, the host. Let me see if I can find this spot where he comes in. I don't see him. What's this? Yeah, see Blake. It shows Blake Neff here somehow. I don't know how these work, but at some point Blake gets on and talks.
P at best at those, and then it's variables.
See, here we go. Why can't it be smaller? Why can't it be? That's annoying, guys. How do you work this shit? I'll find it. See, it says questioning Blake Neff in here. And then it's the spaces. But somebody had an actual this is it.
Fly down from Phoenix.
He flew down that day. He flew down that day, or flew up, I should say.
From where?
From Phoenix,
Oh, okay.
or for wherever he flew in from. I don't want to say from Phoenix.
All right,
so Blake, somebody was asking you a question about coming on.
There's too many people talking. Like, everybody shut the hell up and let one person ask a question.
Phoenix and Glenn Beck said it. Glenn Beck said it was from Phoenix.
I'll be honest, like a lot of you
Glenn
guys,
Beck doesn't work for us, but
I've been listening to this for a minute. Like, guys, a lot of you guys.
But then, he wasn't able to come. But when did Andrew fly down from Phoenix?
he flew down that day. He flew down that day, or flew up, I should say.
From where?
From Phoenix.
Oh, okay.
Or for wherever he flew in from. I don't want to say from Phoenix.
That's like not even the part of I heard. I wish I could find the right thing. I don't know where it went though. They got me messed. They got me pissed. I thought they had it. I thought that one from Blake was actually him talking. There was one where he talks about it on that Spaces, and he talks about something. He talks about Terrell Farnsworth. I just can't find it. Oh gosh. These guys are so annoying. Oh shit, Candace, another post from Candace over on X. Wake up, Andrew. We need another manufactured live from you to clear this up. You texted me back at 12:40 a.m. Utah time and told me that you didn't know anything other than Charlie had been pew-pewed. Can you tell us why Ben was seemingly receiving updates before you while Charlie was en route to the hospital? Did I mention that Ben's security team is current and former IDF? I know this because I used to work at the Daily Wire, Andrew. Can you let us know who on Charlie's security team was available to provide instant updates to an IDF security attaché, and why Ben Shapiro was deemed significant enough for that information during the crucial minutes when they should have been focused on saving Charlie's life, collecting evidence, and or pursuing his alleged unalivers? Seems a weird time to take a phone call from Ben's IDF security team, no? Wake up, Judas. We want answers. Oh, shit. Oh, shit. When Ben provided the figurative 30 pieces of silver and publicly pledged to give you guys $1 million a couple of days later on Charlie's set, how did you and Blake feel? How does money like that feel, Andrew? Did you let him look at the bloody mic he told the world he would pick up? Inquiring minds who still have souls want to know. It was you that booked Ben on Charlie's show a couple days before Charlie's death. Charlie was upset with you about that. Was this to seed the idea that Charlie and Ben were friends? Do you have the stomach to try to tell the public that today? Say it, bitch. Say Ben Shapiro was Charlie's real friend and Candace wasn't. I want to hear you try it. Oh my God. Candace went off. Oh my God. Bro. Oh, fuck. Candace just went off. Oh my gosh. Oh my gosh. Oh my gosh. And that isn't even, I don't even think he answered this. And she tagged Blake too. Literally. Let's see. These are just, these are comments under it, right? Is this the comments under it? There's no like comments. Let's see. No Andrew, no Blake. These are just people still calling them out. Andrew, calling out Andrew, Blake, Ben. Oh my God. This is 2 hours ago. You have to love Philadelphians. They love the idea of blackmail and secrets used to humiliate people. They really thought Jeremy accomplished that here. These dumbasses don't know that I already shared this information with my podcast audience in the wake of Charlie's unaliving, as I detailed why I parted ways with my security team. The literal kryptonite to Zionists and Philadelphians is simple honesty and truth. Yeah, somebody tried to bust her on something, and she's like, no, I already told people that, you dumbasses. So stupid. Young Ben Shapiro gets defeated by a punching bag. It's Ben Shapiro? That's hilarious. We should save this one, guys. Whoa, dude. We'll watch it again. Go for it, Ben. Go for it, you big badass. So good. That's the best. That is great. That is amazing. He's running away crying like a bitch. He's a little bitch. What a little bitch. Benny Bitch Shapiro. You can find more on Ben Shapiro over there on my video that I put out. Yeah, Candace just went hard. She called Andrew Corvette a bitch. She called him a little punk bitch. I can't wait to see if he answers. Yeah, so obviously he's quiet now because, you know, that's what they do. They don't like to, heaven forbid, heaven forbid they speak up. Yeah, we remember them better than they do. Yeah, then the weird story of him collapsing on the tarmac into Erika's arms. Yeah. Yeah. Blake is such a wiener. Yeah. Blake is a wiener. Ball height Blake. All right, we are waiting for court to resume. Something happened here because they said they would be back 30 minutes ago. They were supposed to go 15 minutes. 15-minute break. They were going to be back 5 o'clock my time. It's now 5:31. That's 31 minutes over the time the judge said he would be back. I don't understand how this court actually runs like it does, because there just seems to be so much like fuckery going on in this courtroom. I don't get it. Yeah, they are a bunch of wieners, Jen. Honestly. Blake, Andrew, fucking Ben Shapiro, they're all little wieners. They'll remind me of each individual nut sacks. Like, Blake's the left nut, Andrew's the right nut, and Erika's the dick. And then Ben Shapiro's just, I don't know. He's like his own hairy ball sack, I guess. He's his very own hairy old ball sack over there. Yep, Candace is out of fucks. She doesn't give a single fuck no more. She just went off. Yeah, I don't know why they're on break. They were just going like on a 15-minute break when they went out. It was at 47 when they left. They were supposed to be back at the beginning of the hour. It's now 32 after. So they're almost gone an hour. This is crazy. Like, if they don't want to do court, we don't need to be sitting here waiting for them. This is crazy. Thank you so much, Alan. I appreciate that. Yes, please hit the like if you are just popping in. If you've been here, hit that like, subscribe. If you're new, we're trying to make it to 1 million subscribers by next week, but I'll be happy if we make it to 6K today. We were at 5943. We only need 57 subscribers to make it to 6K. How exciting would that be if we could hit 6K today? I agree, Derek. I think she has some info as well. Yeah, I am going to give them another couple minutes and then I'm hopping out of here because you know what? We all got shit to do. We can't be waiting around for these ridiculous idiots to decide to come back to court. When he says there's a such and such minute break, that's all it should be. What's going on? Did somebody try to escape? Did one of the attorneys get into a fist fight with another one? Did somebody walk in the courtroom naked? What's happening here? We're all waiting. And court gets out of here like in 26 minutes anyways. Court's done in 26 minutes anyway. The whole thing's over with. They only go till 6 o'clock our time. It's 5:34. So I think literally they're just doing something stupid. Something happened. And yeah, Barron comes on at 6, I think, tonight. I'm watching the whole thing. They do shit like this on purpose. Yeah, they'll come back and say something super important before they then leave. Crazy. They want everyone not to watch. That's what I mean. That's why I don't care how many people we get in the audience. We're tuning in and just gonna sit here and watch it, you know? I think we have to show them that we are all watching them. Like, don't misstep because you got the whole world looking at you. And I think they definitely need daily reminders of that. Daily reminders. There's thousands of people watching this live. So you better make sure you do it right. Even though they still aren't doing it right. I think that one girl, I think her hair got caught in something because she forgot to brush it today before court. I think it got caught on the belt buckle of somebody else in the courtroom, and now she's stuck, and they're trying to get her hair out of there so they can continue court. Yep. Like, what are they fucking doing? I wonder if like anybody even knows what they're doing. Let's see. What are these guys saying? These guys are looking at videos. Are they even talking?
Guys, we're just waiting for court to restart and we're trying to find some funnies.
Yeah, I can barely see, but hold on.
Why can you barely see?
Because I'm old. I don't know.
You're not old.
Okay, here, click on, there's a few holes in the Charlie Kirk one. How about that? That's the middle. You can see left on the roof.
You're not old.
Tyler shoots Charlie Kirk. He runs across the roof. His shadow disappears for some reason. He's like running and he has a shadow, then boom, no shadow as he crosses the rest of the roof. It's like the CGI guy quit halfway through. He's like ethically.
I'm trying to pause it. The reason there's no shadow is because it blows out in the highlights.
Cannot complete this job.
Let him be funny.
Basically, Tyler uses his great-grandfather's rifle. The story is that his great-grandfather used his rifle in World War I. His grandfather used it in World War II, and then Tyler used it to start World War III, apparently. I think that was, and you see him running and then jumping off. Just like where did the rifle go? Did it bend with his leg? Some people say, well, actually,
He wasn't in his pants
he didn't
anymore.
have it in his pants at that point. He has it under a piece of cloth. He disassembled this right after he shoots.
No, he didn't disassemble it.
All right. I'm not gonna. This,
Look,
this
she's
is
getting
this
mad.
is not gonna work. If you could,
she's like, just let him do his routine.
It takes away from it all. Okay, folks, what would you like to discuss while the court is on recess? If this is no good.
Look, my live isn't showing up for them guys. That's rude.
What happens if I do this?
They should click on
25
my live.
minutes ago. Oh, you just published a video.
Mm-hmm.
The court recognizes the importance the constitutional rights of Mr. Robinson being upheld and protected. At the same time,
Yeah. I don't know. I can't see the chat. A lady, it's on the side of the thing there. I tried to make it pretty big, but we're watching other videos just to wait for something to happen. I thought we would see if we're just looking at the wrong channel or what, but allegedly there's some craziness going on in the courtroom right now. And we don't know where this judge is at. We don't know what he's up to, what he's doing. It's just complete and total chaos in the courtroom. He is not attending his own court. He's out doing other shit. Baron Coleman over on X posted 6 hours ago, I genuinely hope this gets answered. Why in all the chaos of trying to keep a man alive did someone think, you know what we really need to do here, men? We need to make sure the podcaster Ben Shapiro knows what's going on before we get to the hospital. Because that's weird. That's weird. Indeed it is. Indeed it is. Why does anybody tell Ben anything? Why is Ben still even getting views? I think the world... Oh, wait, I'm hearing something. Hold on, something's happening.
court is back in session.
Oh, thank the Lord. Here we go,
Noting
guys.
the presence of counsel and all parties, I appreciate your patience.
Really?
Sometimes it takes time to save time, and so that was the intent of this court.
What?
In addressing what is before this court as it relates to State's Exhibit 16.
Oh, God, here we go.
Counsel, this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance, as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because I do think a closed hearing is appropriate. There are, okay, setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinsin. Okay, Mr. Robinsin said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinsin. Okay, I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it because the court's decision to allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it in the
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed. We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinsin's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party. We have not filed anything in this case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinsin's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's so I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand, what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twiggs' video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me. But it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with audio. But hearing the tone, the context, all of that, that's why the state chose to do.
Oh my gosh, she got to shut up soon.
Statement from
I can't
Mr.
take her
Twiggs.
voice.
We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Sure.
Citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here, and I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right. Thank you. I appreciate both parties advocating and arguing. It's helpful for the court. Right. So in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to.
Holly, I love your avatar, by the way. Nice,
right
nice.
Is that at 8? Well, let's start. Starting on page 6. Now, let me go back here. Starting on page 6, after 6 minutes and 56 seconds.
Hey guys, somebody in my comment section of my latest video, somebody in the comment section said that Ben Shapiro came out and said that on his show about Charlie Kirk's security team contacting his security team to establish perhaps a reason for a phone call, and like say if they were to subpoena these phone records, there would be, well, I admitted in that video there was a reason why his security team was contacting my security team, right? Somebody said perhaps it was a phone call to say like the job has been complete, and Ben is just saying like, no, they were updating me on Charlie's condition while he was on his way to the hospital. And that really made such good sense to me. That makes perfect sense, right? Why else would they call Ben Shapiro's security team? Charlie Kirk's team contacts Ben's security team on the way to the hospital. I think that's 100% true. They were trying to establish a reason for the phone call, because why else would Ben come out and say that on a video like right now? Why would he admit that right at this point in time when he could have said that all along? He's never said anything. Super, super crazy to me. And now we can put this on faster, I think, because I paused it. Let's see. It works until it catches up. He's still looking at papers. Good Lord, they had an hour to do this behind closed doors.
To 20 minutes and 27 seconds. for reasons such as 403, under Rule 403. And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights.
He's just using that lady's words now. She's the one who said, we need to take a narrow approach to blah, 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 blah. And why are they using Lance Twiggs? Basically, him saying, like who said that? It's his confession they're using. Instead, they're using Lance Twiggs's thing as a confession for Tyler Robinsin, which is absolutely that's obscene, and that's just so crazy to me. What are these people doing? This is like a travesty of justice, in my opinion.
It is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Restate those times again, Your Honor.
6:56 until right the line before 2027 or 2027, just so until 2027. Is that? And then and then what the court indicated previously from 32:55 until 35:48.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for Your Honor's consideration.
Right, so kind of going through my three-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance and everything that everything that Mr. Novak noted. I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
Thank you, Your Honor. I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make a conclusion at this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today, that many of these references are to text messages. Again, the public doesn't have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurked in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency.
This kid needs to go back to daycare. His outfit doesn't even fit him. He put on his dad's coat today. Why is there a 12-year-old standing up here in court?
Generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this.
That is true, though.
I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And, all right. Counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and that your mic's muted.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau. My French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite to Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says we constructed a rule. Now I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole of what were all the different opinions in Rideau and why is Esty citing to a dissenting justice. But what Esty said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment.
I mean, it feels like the judge is trying to be fair. He does really let them get everything they want to get out. He double checks, like, do you have anything? Anybody else have anything?
Estes' opinion was written by Justice Clark.
He's trying to understand, it seems.
There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion.
And what?
And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to (20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 3255 until 3548. Does that comport with what I previously said?
Yes.
All right. And then from 3548 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erika Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act, but I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
If we have just a moment.
Of course. And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
I agree with that, Silver. It's not a balancing act. I found that pretty disturbing too. When he's like, you know, we're trying to balance the Constitution. Like what? No, not at all. It's not a balancing act. You uphold the
Judge,
Constitution.
it's the state's position that we close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis. As to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinsin. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood. Right. But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time, so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank you, Mr. Novak. And if you would mind, obviously, sending a copy to the state as well.
Oh, of course,
so it's not
of course.
ex parte. All right.
So, is the court referring to a formal filing?
No, just if you
A bench memo.
A bench memo, and that all sides can have a take a look at, just to prepare, again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right.
Are we dismissed?
Is there anything else for this afternoon?
Can we leave?
Not from the state.
All right, to defense.
No, thank you very much.
All right.
All right.
Hooray.
Court will be in recess until 9 o'clock
We
tomorrow
made
morning.
it, guys. We made it through. We made it through. We have made it through. Praise his light. Praise his light. So all good until tomorrow morning. So I suppose we will be back tomorrow morning. We'll try to get here a little bit early because I do have something, I think at 2-something o'clock tomorrow. So I might leave it run so we can watch it here, and then I'll just have to come back to it when I get back. I think I can do that because it goes till 6 o'clock, 6:30. But Barron's coming on. I'm going to go watch Barron with you guys. So thank you all so very much for stopping by to hang out. I love you all so much. Please don't forget to hit that like button if you did stay here or if you popped in for a second. Hit that like. Make sure you're subscribed. We're going to reach 6K today. So tomorrow morning when I see y'all, we better be at 6K. It's closer to 1 million. All right? Have a great rest of the evening. And again, I love you all so very much. And I will see you tomorrow morning bright and early for the next court appearance.
It's a wrap on this life.